Hey everybody, so welcome to the first edition of Let's Talk HR, presented by myself, of course, Bandile Solenjani. And in this edition, I want to talk to you about what to do when you are served with a disciplinary notice. I know nobody wants to find themselves in this situation, but it happens, So there are 10 things that I will list that you need to cover in order to prepare yourself well for that disciplinary meeting. Number one. So the first point is that you must be given reasonable time to prepare for the hearing, and the standard time is 48 hours that your employer must grant you in order to prepare. You may then ask that the hearing be written in a language that you understand if you are more comfortable in your native tongue. It is your right as a South African to be able to present yourself at a hearing in a language that you understand. You also need to make sure that you understand the contents of the hearing notice. If you do not understand them, ask your HR manager or the line manager serving you with the notice to explain it to you. I know sometimes the environment is very hostile, but ask anyway. The second thing that you need to ask your employer is that if you will be given a chance to challenge the evidence that will be presented against you. In some cases, you can then ask for that evidence the 48 hours prior as you prepare for your hearing. If your employer refuses to furnish you with evidence, it means that will not be a fair hearing, and you have a right to take that to the CCMA. But do not, under any circumstances, decide that you will not attend the hearing. Attend the hearing, as unfair as it may be, and then you may challenge the outcome of the hearing at the CCMA. Chances are your employer will be found to have been procedurally unfair. Another thing that you need to check as an employee is that has the hearing followed after reasonable time that the incident has taken place? Some employers leave the hearing to 2 months or a month later. That is already procedurally unfair if a hearing is being served on you a month after the incident. So make sure that the incident has recently taken place and you are then being asked to answer for events that have happened recently and not a month ago. Our memories are not as sharp a month later, as well as some of the evidence may not be relevant in a month's time. Another thing that you need to make sure of when you're being served with a hearing notice is, are the charges on this hearing notice charges that you are aware of, number one. Number two, where do the charges fall on your company's disciplinary code of conduct? So you may ask the employer to furnish you with a disciplinary code of conduct, which you can reference the charges. Sometimes employers duplicate charges, and sometimes the charges are things that don't exist in labor practices. It is also very important that you remember during the time of the incident who were the witnesses that were present there. And if there was more than one of you involved in terms of the transgression that you are being charged for, then you should find out if the other employees have been charged as well. That will show fair practice. Another thing that is very important is that you need to make sure that if you have witnesses that are coming to your hearing, that you have given a reasonable notice 48 hours prior to the hearing that you would like to call upon certain witnesses, as well as if the employer is going to use certain witnesses against you, they need to give you 48 hours notice in order to make sure that you are prepared for those witnesses. Sometimes people want to ambush each other, and sometimes the chairperson will not allow witnesses that are called on last minute that were not part of the incident. However, it is your right to call witnesses, and it is your right as a person who's being accused to cross-examine those witnesses that have been called. Now, once you've gathered all your witnesses, ask for statements from those witnesses if they are willing to provide a statement to you. If they are not willing to provide statements, then you can subpoena them for the hearing, and you can cross-examine them based on the evidence that you have and based on the evidence that your employer has that you would like to dispute. Another thing that commonly happens when it comes to hearings is that employers refuse to give their employees the laptops in order to challenge the evidence that is against them. And in some cases, they refuse to give paperwork relating to the incident. So when those things happen, you should make it known to the chairperson when you attend the hearing that you were refused evidence of that nature. And if it happens that they want you to have a look at the evidence during the hearing, you should ask for a postponement in order to examine the evidence, because now you are being ambushed with evidence that you have not seen prior. And last but not least, good luck, Godspeed, and may the odds forever be in your favor.